kind of situations where, say, Professor Raymond Atuguba will do what he does as a survey, and he does what he believes is an academic work, subjects judgments to a certain analysis depending on who appointed the judge and so on and so forth, and how they made their decisions. And he is declared a persona non grata in the courts. Okay. Then you have, of course, Professor Kokwaza, and let's be frank about it. Professor Kokwaza, because he doesn't practice in our courts, he has all the liberty to say all the things he wants to say. There are lawyers who feel strongly about certain things. They will pass it through him, and you hear him advocate it very strongly. You cannot say some of the things that he says. Do you feel that now the Chief Justice is opening up in a way that will allow you to make your criticism without looking back and asking, if I go to court the next day, I'll be welcome or not?
But I hope this is the start of the opening in terms of that. I am one of the people who believes that discussing extant cases, even on air, gives better elucidation and also even helps the judges. I am one of those who believe that even if you are not, like you say, you can be fair without being, impartial. And I like it when
without being neutral, you mean, or
without
impartial?
being neutral. Sorry, the words I was looking for. I like it when I watch, for instance, Americans, discuss cases, and you have constitutional law Professor Tribe of Harvard University, retired constitutional lawyer, Justice Lutich, and very serious people discuss the case, and later you get a ruling. Let us be clear about this. The rulings of the courts, not just the Supreme Court, courts, can be discussed after the fact. The rulings of the judges can be criticized. And it is absolutely necessary for academics to be able to look at those rulings and do what Professor Atuguba did to them. Even suggest that how people are appointed as a terror has some effect. Their leanings, their previous, inclinations, and all kinds of things.
That's what you were taught in law school as American jurisprudence, right?
Yes. No, I'm coming.
I'm saying that thing you were talking about, what Professor Atuguba did. Okay. Go ahead.
Yeah. We will get to the point when we are sufficiently matured, where those things will actually be welcome. Right now, I think people are a bit too sensitive, and that is why we are going the way we are going. But let us be clear. What Professor Atuguba did is right. More of that ought to be done. Before the time runs out, let me make this case clear. I hear my brother, Dafia Meko, but please, let's be clear about this issue about the judge being a registrar. The judge is qualified to be a registrar, and nothing stops the Supreme Court from doing that. Indeed, like you said, there's another registrar who is a judge. That is number one. Number two, if the person is a judge and is a registrar, the question is whether their job as a judge is suffering or not, period. If they are performing their job as a judge well, and they are also acting as a registrar, I personally think it's a better thing than otherwise. Listen, what registrars do, even though they are not judges, has very serious judicial effects. That is procedural justice also. So for me, I was happy when that particular judge was made a registrar. The only issue is that she should not make her work as a circuit court judge suffer. Indeed, I am before her on a number of cases, and I can tell you she's a very good judge. And so far, I can't complain about her work as a circuit court judge. So let's be clear. There is no impediment in making a judge a registrar. Indeed, it is advisable.
Okay.
Provided her work as a judge.
Do you think, as some...
And I agree with the partner that...
Do you think, as some suggest, that your CDD Afrobarometer 2020 had a revelation that you should not be saying what she's doing is rare, but it has become necessary? Because the Afrobarometer, Ghanaians demonstrated lack of trust in most of the state institutions, including the presidency and the rest of them. The judiciary, 85% of Ghanaians perceived judges and magistrates as corrupt.
And I have said over and over and over again that much as perception is relevant, that particular perception, I believe, is not well informed. If you look at the volume of cases that go into our courts, and the fact that 90% plus, I believe, does not come up to any serious scrutiny. People go to court, they suffer one or two problems. I mean, I don't have time to give you examples, but I mean, they say all kinds of things. You pay the judges. I think that perception is misinformed. But that is why I believe what the Chief Justice is doing is good. Demystifying justice delivery is always good. There is too much mystery around it. So the transparency in empaneling will be useful. And I agree also, the Supreme Court is a bit too overburdened, lightening their load issue. They can issue rulings without hearing and not breach any rule. I've argued that point somewhere, that you file your processes, they can look at it, let them, write it out and let you come for it without hearing you. Now, the problems come from the lower courts. That's where the majority of the issues are.
Yes,
so
Kofi,
again,
Kofi, as a practitioner, I will not hesitate in sharing your view that it is a small number that may be the ones giving the judiciary a bad name. But does it not matter? Just as we have discussed the scholarship secretariat, the outliers matter, don't they? Take the Supreme Court, for example. When the political issues come up, public interest issues come up, the question that the judiciary and lawyers often ask is, what is the percentage of the so-called political cases that, you tend to use as the measure, or to measure whether the Supreme Court deserves the offensive, unanimous FC tag, etc. But we forget that that is exactly what needs addressing. The one small bad nut spoils the entire, handful of nuts that you put in your mouth. Is that not it?
It is, and that's where I was going. Where I was going was that the problems come from the lower courts. And the problems arise out of a lack of transparency on how the lower courts operate, and the fact that the workload is such that sometimes the judges themselves, skimp over so many things. So I was going to say, we should put more resources at the lower courts in terms of more justices, and I agree with more ADR and co. When we create that heavy duty capability at the lower courts, I believe these things will go down, especially if there's more transparency also in terms of the justice administration. All right. So I agree with what the Chief Justice is doing. What I want is for it to trickle down quickly, okay, so that there will be more capability at the lower courts, more transparency at the lower court. I mean, I have been able to go to court, and the judge has heard me and vacated her ruling.
Right.
All right. Now, somebody would think it's influence. It's not influence. When you make good, arguments, it's possible.
Yeah, we have all encountered those in the courts before.
So, when people talk about judges are human.
All right. So she says that she's going